We have with us, and I'm only going to pronounce the first name Nana, because the second name is very complicated. Can you pronounce?
Mchedlidze.
See, that's impossible for me. She is, and we are very much honored, from the Tiflis State University in Georgia. We are happy to have you here. We have several different cooperations, a little bit coming and going with universities from Georgia, namely Tiflis State University. We have a wonderful group of students with us. You met the Georgian students already?
Very active students.
Very active students. We are happy to have them here. We are thankful, I may say, and it's important to say that also with regard to the recording, we are very thankful for the European Union and Erasmus Plus money that makes your visit possible, and that makes also the visit of the Georgian students with us here this semester possible. Erasmus Plus is such a wonderful program, and it's great to that we have this possibility. Currently, it's still with regard to your home country Erasmus Plus, but in a very short time it will be Erasmus, because once you join the European Union, then we don't need the plus anymore. The Erasmus Plus program is for countries, cooperation with countries that are not yet members of the European Union. Once states are members of the European Union, it's only Erasmus, so to speak. Well, we see, that's politics, of course, we'll see. Nana has received her legal education, of course, at Tiflis State University in Georgia itself, but then in Birmingham, United Kingdom, Warwick University, UK, and Utrecht University, the Netherlands. So very European international academic education, where she received in the UK and the Netherlands masters, LL.Ms. She has concentrated her more or less entire professional career on the European Convention on Human Rights, if I may say that. Very much into that, not only with regard to teaching, but also with regard really numerous expert and consultancy work with regard to the Convention and the European Court of Human Rights. Quite impressive to have a look at that in detail. As I said, we are very much happy to have you here. We are honored, and we are very much looking forward for a fascinating, very challenging, very sensitive topic, balancing security and human rights, covert surveillance and the limits of effective investigations, a topic that brings together human rights, public international law, constitutional law perspectives with criminal law, criminal investigation. Looking very much forward. Thanks again for the audience, and you have the floor.
Thank you, Professor Tietze. Good afternoon. Hello, everyone. Thank you for coming. Mchedlidze from Tbilisi State University. I also am professor at Alta University, Georgia, and my dissertation, which I defended on the reasoning standards of Strasbourg Court, their application by domestic court. As Professor Tietze mentioned, my entire professional and academic career is about the implementation of the European Convention standards. But before diving into today's topic, please allow me to take a little detour, not into academic legal doctrine just yet, but into gratitude. I would like to express my immense gratitude first and foremost to Professor Tietze for placing trust in me without knowing anything about me. I hope that today I will meet that expectation. Professor Ręczykowski, who took me under his academic wing, he let me step into his classroom and showed me around the university, beautiful buildings, and told me the rich story behind them. Professor Büttner, Professor Bade, who welcomed me into the classrooms and showed me the high-level legal teaching, what it is really about. Dr. Lyubov Zazulina, Mrs. Katya Richter, Professor Azar Aliyev, they guided me tirelessly through the intricate labyrinth of a very complex academic exchange process, and I thank them. So I hope this won't be deducted from my speech limit, because, yeah, I wanted to start by acknowledging those whose support paved way towards this legal discussion, which is starting right now. No worries. So, balancing security and human rights, covert surveillance, and the limits of effective investigation. Here are the cases of the Strasbourg court that I'm going to discuss with you today. And the facts cannot be more different in these cases. But I'm going to link them together with a common thread, and I will take these three key points: security surveillance type that was used in these cases, investigation interests in those cases, and procedural safeguards that were required in those cases. So here is the list, and let us start with a subscriber metadata request. Metadata sounds very innocent. It is the data that describes other data, and it's separate from content. So, for example, call logs, who called who, without the content of communication. Sounds innocent, right? But it cannot be so innocent after all, and we are going to discuss to see how aggregate metadata can be very dangerous for the right to respect for private life. Here, there is no interception, so let us see this Paya versus Germany case, very interesting. So, because these are huge cases, I have this method. I will give you a brief summary, and then we'll dive into more details, okay? So what this case is about, we see here. Authorities accessed basic subscriber identification data from telecom providers, and it was to link SIM cards to individuals. Law enforcement and national security purposes at stake, less intrusive, less sensitive data, we'll see other examples and compare, adequate legal safeguards, and the court did not find the violation of Article 8 of the Convention, which is the right to respect for private life. But you see which safeguards are missing? In red, court order and user notification. What an interesting case. We are missing these key safeguards and still no violation of right to respect for private life. So we'll see why. What are the reasons behind? Obligation to register personal data when activating prepaid SIM cards. And all this information is stored with the telecom providers, names, addresses, dates of birth, which are linked to these phone users, right? And retrieval can be done without court order, without prior notification of the users. And this information is used for law enforcement and national security purposes. Your Federal Constitutional Court upheld the law, so the applicants turned to Strasbourg Court. Article 8, I will just mention Article 8. It's all about Article 8. It's right to respect for private life. So it's the relevant right here. Strasbourg Court said that it would only assess storage of information, not its subsequent use, right? And Germany was afforded quite a wide margin of appreciation because there is no European consensus on this kind of issues. When there is no consensus, then margin of appreciation is wider. And that was what Strasbourg court said in this case. So now we need to see the interference. Was it severe? Was it limited in its scope? It was limited according to Strasbourg court. And I started with this case, not only because it's against Germany, but it is a very interesting case how we start from a very moderate interference and how it intensifies. No communication content, no location tracking data is stored, and no sensitive data is stored, right? No personality profiles created. And we'll see a case versus United Kingdom involving creating personality profiles. And there was violation in that case. Let's keep it in mind. So, data storage conditions, what are those? The database is secure. There are no glitches, no problems, no leakage, no anything. So everything is fine. Only identification-related data is stored. We saw, right? It's name, date of birth, and such like. And it is storage of this data is limited to 1 year after the contractual obligations. Contract expires between the individual user and the telecom provider. So now who can access this information? Authorities can request the data, and the list of those authorized to access this data is quite broad, but it is strictly limited to law enforcement and security, effective investigation purposes. And it is functional. If someone requests an information, they should reason why they need it due to their official duties, and it needs to be substantiated. It is it needs to be necessary. No oral requests are allowed, and Federal Network Agency assesses the admissibility of these requests. Also, every request for data is logged so that to allow monitoring and data protection. Independent supervisory authorities are involved in the supervision, legal redress available under general law. And we see, despite absence of court order and lack of user notification so that they could challenge the use of such measures, right? Despite these flaws, we have no violation of Article 8. Now we'll move to another case. Targeted metadata analysis. Dynamic IP profiling. Dynamic IP, Internet Protocol, it denotes IP which changes every time a device is connected to Internet, device is rebooting, reconnecting. So it is different from a static IP address which does not change. So we have summary here, please. Authorities requested Internet service provider to link, see again, link a certain dynamic IP address to an individual. In the previous case, we had information linking to a SIM card owner. So now IP address linking to an individual. Spoiler alert, violation of Article 8 in this case. This allowed them to reconstruct specific online behavior thanks to this IP address. And ECHR ruled that such access required prior judicial authorization. So we see a difference based on the severity of interference. Well, there was no user notification, no judicial authorization. Here we are lacking judicial authorization too, but we see that violation takes place. This is a ruling of Strasbourg court. So let us see this case in more details. This was police notification by Swiss police authorities within the Mutual Criminal Assistance Agreement that certain dynamic IP address was noticed in child pornography file exchange through that peer-to-peer network, and without court order, police, Slovenian police, based on the information that was supplied by their Swiss counterparts, they compelled internet service provider to supply that information, who was linked with this dynamic IP address. The IP address was disclosed afterward, and they, as I already told you, depending on this IP address, you can see the search history, and what that search history gives away: lifestyle, interests, what are the person's choices, and all that. So it's really different from the metadata that we discussed in the previous case. Based on this information, later police obtained court order and conducted home search, and all the computer electronic devices, they were seized. And then it turned out it was not the subscriber, but the son of the subscriber who had this material, files on his computer. And he challenged that his rights were violated because he was convicted based on the information the police obtained without court order. So what are the safeguards here? Investigation interest is quite clear, self-explanatory, right? Child pornography, serious crime, and integrity of children should be maintained, respected, protected by the state. It's positive duty. So, this address is a personal data. It is a metadata, but it denotes information that is not available publicly, like phone books or car registers, right? The service provider had to process information manually. It was not readily available, and only within the days that information was furnished to the authorities. So, disclosure links user to specific online activities. Such information may reveal interest, beliefs, lifestyle. Important aspect of right to privacy. So, now could you please tell me what you think? Did this person have a legitimate expectation to stay anonymous? But well, he had a dynamic IP address. Yes, it changes. Do you think it? What would be your argument? What would be your thoughts? You say that he wouldn't have any legitimate expectation to stay anonymous, right? Why?
I mean, the case is about child pornography, so in this regard, I would say he has no legitimate expectation, but of course, in general, I would say he maybe has a legitimate expectation. His behavior online is disclosed privately. Yes.
So you agree that he would have expect legitimately, and that's what the court said. It agreed with the Strasbourg court agrees with you that yes, despite the seriousness of the activity, that person had the legitimate, reasonable expectation to stay anonymous because of his actions, because he chose dynamic IP address first of all. He never made his name known. He was using some nickname, and he always tried to hide his activities. So this is the key. This is the key. But it does not go up to that. He does not have, of course, other rights, right? But we need to assess whether he has reasonable expectation to stay anonymous. And that reasonable expectation also obligates the state to use the necessary amount of procedural safeguards. This is about counterbalancing factors that then need to be procedural safeguards in place. And they were not. They were not. Police was, sorry, yes.
Did Slovenia argue against this reasonable expectation?
Yes, they did.
What was their argument?
They argued that this information, it was very innocent. It only denoted some address. He was not even identified by that dynamic address. They suspected his father first. So they tried to say that he did not use VPN. That was the main argument. VPN, which conceals, that was the main argument, but they also tried that this is very innocent. It's a metadata. It's not the communication. We did not see the traffic, internet traffic, from the IP taken alone, but Strasbourg court did not see it that way. So VPN, the fact that he did not have VPN, he had dynamic IP address, and he did everything in his capacity to stay anonymous. So this was the key for the Strasbourg. But it's just at this point, we will see how the case will unfold, right? It depends. These cases are always about personal interest, state interest, which of course involves and implies the interests of others. But the counterbalancing is about procedural safeguards. And this is what Germany's cases are all about. We saw the previous case. Here we do not have this procedural safeguards because police just use criminal procedure code to get the data. See, the act did not regulate disclosure of IP subscriber information. But we saw how detailed German legislation was in this regard in the previous case. Here we have nothing. It was not even foreseeable for the person that his data would be fished out like that. And no rules on data retention, safeguards against misuse. We saw in the German case that how secure the database was, who had an access to this information, how it was protected from misuse and arbitrary use. We don't have anything here. So here, safeguards are more important than investigative interests. Can you see the shift towards procedural safeguards? Very strong investigative interest, child's integrity, but procedural safeguards are missing. So this is what I'm trying to show with these cases. The intervention, the interference intensifies. There must be parallel dynamic of intensifying these procedural safeguards. So, no independent review or supervisory authority involved. We had all that in the German case. Disclosure allowed police to identify person behind IP and track activity, and violated the standard of foreseeability and legal protection under Article 8. No procedural guarantees. Well, no monetary award. I just included this case because there would be some sense of unfairness. Why? His right was violated, but he got no monetary award. So now we move to even more intensified interference with the right to respect for private life. Real-time audio is more serious, right, than just metadata. It's already the content. We discussed metadata, now we have content, audio surveillance. Geolocation surveillance as well. Ben-Pfizer versus France, 2018. Communications metadata through telecom operator based on court order. This is a summary. No violation of Article 8. Real-time geolocation and communication surveillance. Initially it was ordered by a judge, but later it was ordered through administrative procedure. So here we have the similar problems, insufficient safeguards, especially the lack of judicial authorization, and the scope of surveillance, because see how many methods of surveillance are used in this case. Communications metadata, this is calls from tower to identify who they called and how long this calls lasted. We have communication surveillance and we have real-time geolocation tracking. So Strasbourg court said it was borderline interference in private life almost in its entirety. So we have very intensive interference with the right to respect for private life. So let's dive in this case, and we have, see, first measure that was applied against Ben-Pfizer and his brothers. They were suspected of having committed serious drug offenses, series of them. First we have court order, which instructs telephone operator to provide records of incoming and outgoing logs from phone lines and to transmit the list of cell towers that had received a ping from the mobile phone. Very technical data, but we understand who called who and how long that conversation lasted. Do you think it's metadata? There is no content. There is no content. Metadata taken alone, less intrusive. There is a court order. What do you think? Would the court find violation in this regard? Call. This is historical calls, means it's not real-time surveillance. It is about just the call duration and where they were made and all that. What do you think about the intensity of intrusion into private life? Is it too much? Court order is there? No. Yeah. There was no violation in this regard. But here we have another one. Decision of the investigating judge. A device was installed on the applicant's car which captured, transmitted, and recorded conversations of the car's occupants and also the real-time geolocation. Based on the data obtained, the entire map of the movement was drawn. And they were caught based on that evidence because they were linked to the location of one of the attacks. And they got convicted based on that evidence. And now they are challenging that before the Strasbourg court that their right to privacy was breached. Strasbourg court agreed because, see, only the initial phase was allowed by the judge, and then it was an administrative procedure. Also, the aggregate and cumulative effect on a person's private life, that the communication is overheard and the geolocation is tracked. Very serious interference into their right to privacy. Would you agree to that? So, Strasbourg court said that the entire process was not ordered and based on court authorization. That was a huge problem. There were no clear basis and safeguards were missing. And there is a very interesting link to the German case, Uzun versus Germany, 2010. See, in that case, Germany presented very compelling picture to the Strasbourg court, how they afforded procedural safeguards regarding geolocation. And France tried to copy that after the judgment was made. And this is how it should be done. Strasbourg courts, when I'm talking about these cases, all these cases have erga omnes effect. There is nothing written in the convention regarding this issue. Everything is explained by Strasbourg court judgments, and they form part of the convention text. These judgments explain what the scope of the right is and what the limitations are. And other countries should take those standards into account. France tried to do that, but it was after Benfiza and his brothers were surveilled. So this change into legislation based on Uzun case, well, these suspects, they could not benefit from it retrospectively because they changed to the amendment to the legislation. It was done later. So another problem with that is that France did not streamline the part about communication surveillance. They just copied Uzun's judgment in that part which concerned geolocation. There was no content surveillance in the judgment, so, well, that part of the French legislation remained flawed. So here we have the violation with regard to French authorities, how they surveilled these brothers, and here again, the investigative interest is secondary. The key is procedural safeguards that were missing. So I'm trying to highlight how this interference was moderate, then it got more intensive, and the highest intensity we have in Benfiza case, almost entirely surveilled the authorities, the private life of these individuals. And the dynamic of procedural safeguards, they did not follow intensification of the interference, and that was the problem. The key is the safeguards. So this is the Uzun case. Because it's an old case, I wouldn't go into that, but I just want to tell you that German authorities, they first tried moderate intrusion into private life of the offender, of the individuals. They were suspected of committed serious crimes, bomb attacks. See, they first tried to install transmitter in the car, but the offenders found them, destroyed them. So that's why the authorities tried to use another more serious interference measure, geolocation. You would think, what's the difference? Transmission and geolocation. Transmission is low range, and it's not real time, and the car should be following, while with the geolocation, everything, the stops, the pattern of movement, the duration of stops and everything, it is all mapped out, and it was used to convict the, Mr. Uzun, and the court saw no problem with that, because the way German authorities acted, it was about the proportionality. They used less intrusive measures first, and went on from there with a stricter measure. So Strasbourg court found no problem with that. The interference was proportionate, was necessary in a democratic society, and the intrusion into privacy was counterbalanced with procedural safeguards. Now, communication profiling. It is about a UK case. Mr. Cat, he's very active. He attends all kinds of assemblies. First, he was going to peaceful assemblies. Maybe he got bored. He started to attending more extreme situations, and he's attending right-wing assemblies. And so the authorities started to surveil him. And, well, Strasbourg court agreed because he aligned himself with right-wing groups, and they tended to be violent. Police had all the basis to collect data about him, but they also collected the data and stored the data about him attending trade unions, and it was added to his profile. You would think that, oh, it's a positive twist, that this man is not all bad, he is attending trade union gatherings, but it's not like that. Because this information is stored, there needs to be an investigative purpose for the storage, because it's interference in his right to life, private life. And there was no such investigative purpose. UK authorities, they tried to justify such storage of information just in case something happened in future. It's not like that, and Strasbourg court did not agree with that argument. The personal data in question was overtly obtained. The nature of intelligence gathering, that police would first need to collect data before evaluating its value. Strasbourg court agrees with that. Police role to monitor protests where the activities of the organizing group were known to be violent and potentially criminal. That's all good with Strasbourg court, but Strasbourg court could not agree why the information about attending trade union assemblies would be added and qualified as domestic extremism. So here we have this problem. It wasn't justified, hence the violation of Article 8. And well, of course, the German case follows, where there was no violation. Again, the profiling case. Profiling. So information is collected about Mr. PN, and so we only had information about Mr. Cat, that he attended trade union assemblies, right? But here, look at the information gathered. Applicant's photos, fingerprints, palm prints, physical description, and applicant had multiple prior convictions. Data type, biometric, fingerprints, palm prints, photograph, descriptive. Do you think it's a severe interference into his right to privacy? Would you think that? Strasbourg court said that it was not that severe as DNA samples. As in another case against S. and Marper, famous case versus the United Kingdom. And again, here we have procedural safeguards as counterbalancing factors, and no violation is found in this case. Periodic review of necessity. In the United Kingdom case, the respondent state could not convince the Strasbourg court that indeed there was a possibility of review, and that the information could have been taken out from the databases, because there needs to be statistics that this kind of claims are satisfied. Here, the country submitted such statistical information that this request about deleting data was met, depending on the assessment, and it also was subject to judicial review. So, no violation of Article 8 because of these procedural safeguards. These are the cases, and I want to tell you just it would be the repetition of the previous slides, and I won't do that. I have mapped out the procedural safeguards based on the security protocol used, based on investigative purposes, and these are like, standards for the countries to use. Mostly they are based on German cases because of the pristine record in this security, human rights, counterbalancing cases. I think it will be like a very objective information based on the objective analysis of the cases that countries need to follow these safeguards, and to copy the mechanisms, to copy the procedural overview and this standards, the balance between investigative interests and procedural safeguards is how it is done on a case-by-case situation. So this is the end of my presentation. These are very complex cases. I really tried to narrow them down to several slides and give you the overview how this interference intensifies and how procedural safeguards should follow. This is a method I applied for showing this dynamic, and I think I will continue within my research commitments that I undertook within this exchange program. This is only the iceberg tip. There are bulk interception cases, huge cases, and end-to-end procedures. They are even more complex. So I think that I will continue research in this regard. You already noticed I'm like an ambassador, self-appointed ambassador for German cases because, well, to tell you the truth, this is why I've chosen German university, because when we had training sessions on data protection back at home, it was always the German cases that I used to highlight the standards. And well, every time when I have a training session with legal professionals, we start with erga omnes effect of judgments adopted with respect to other countries. They also have, I push this argument that they have legal effect for Georgia, even though those judgments were not adopted against Georgia, because this is how standards are explained. There is no reference to the standards in the convention text as well. So I can tell you it was a very rare occasion when I did not start with this erga omnes effect, because, well, I think that other countries should learn from your experience, and I think it's an objective assessment. We just went through cases. I know that there will be more informed perspective from the audience members, because I can only give you this information from the Strasbourg court perspective. This is what I read, and this is how I know that these are the standards that Germany can be proud of. Well, yes, please.
I have a question about the UK case.
Yes.
On the slide that there was a specific violation found on the storage, so and storage of legally collected data constitutes a breach of the right to privacy.
Yes.
And yes, have that has been set around the time period of data retention, or is there some other standard?
Time is very important. So let me talk about the storage of information first, because it's processing data and its interference. Whether it is justified, it will depend on the cases. But I can tell you about one case against Switzerland, Mchedlidze versus Switzerland. A gentleman, he got into a car accident, and then he claimed he was unable to work, and claimed 1 million euro from his insurance company. So they hired an investigator, private investigator, who was surveilling him from the street and saw him how he would vacuum clean his house, and also take the trash out and wash his car and everything. But the fact is that the lady, wife, Mrs. Mchedlidze, also came into picture, and her photos were also taken. But because it was just a few photos and she was not the main target, this was not considered to be systematic storage of personal data, and most of those photos were blurred anyway because she was somewhere in the background. So storage, it depends. Her photos were also taken, and because she was in the frame, those photos were presented to the court. As you may guess, the gentleman did not get that 1 million euros as a compensation claim. So, but the information that was processed and stored, it was not storage within the meaning of Article 8 with regard to the lady. So it depends. It depends. Storage again depends. Several photos did not amount to storage in that regard. So let's go back to Mr. Cat, right? In this regard, the mere fact that the information is stored, it means interference in his right to privacy. Right to privacy is not an absolute right, so interference is allowed. And we saw in PN versus Germany case, this interference was justified. But here we have a very important information about the applicant, that he attends trade union meetings, and there was no justification for that. Strasbourg court follows this methodology when assesses the lawfulness, not legality, but lawfulness of interference in right to qualified right. Qualified rights are right to freedom, right to assembly, right to beliefs and religion and conscience, and right to privacy, right? So first, whether the interference is in accordance with law. This means that there should be some domestic legal norm allowing it, but it's not all about that. The quality of the law needs to be there. So the law allowing for such interference, in this case, storage of data, it should be foreseeable. We saw that foreseeability was a problem in Benedict versus Slovenia case. There was no foreseeability, despite the fact that person would legitimately believe he would have anonymity, right? So foreseeable. The law must be accessible. It should incorporate procedural safeguards, and it needs to be compliant with rule of law. This is the first requirement. Then we have legitimate aim, interference that is based on legal norm. It should be pursuing legitimate aim. Legitimate aim is the aim that is allowed by the convention itself for the restriction of a convention right. It's not for the state to add some other interest to that. It is decided by the court and the convention. And the third one, the most important, very difficult, necessity in the democratic society, whether the interference was necessary in a democratic society. And here democratic society is not Germany, not France, not Ukraine, not the United Kingdom. It's a philosophical category. Just you can't reach horizon, right? You approach it and goes further away. This is how democratic society is. So where the human rights flourish and you want more, and the state has to do more. This is what a democratic society is. So whether the interference was necessary in a democratic society, this is the key. It has two categories, whether there was a pressing social need for interference and whether there was proportional, whether interference was proportionate. And both of these subcategories, they need to be reasoned by courts with sufficient and relevant circumstances. Very complex. We have a problem. I told you that I'm reviewing Georgian legislation, its application by domestic courts. Our lawfulness reviewed by some of the courts, Georgian courts, it is limited to legality. They don't go beyond that, don't review legitimate aim, don't review the necessity. And it's a huge problem. Someone is fired from the workplace because, well, he alleges that he made some unfavorable comments about the government. So what is happening? Reorganization, and office discontinues to exist, the office for which the person was working. And what domestic court says, it is legal, hence it's lawful. It's not correct. There need to be legitimate aim and there need to be necessity assessed. And well, in that case, United Kingdom case, they could not justify why this piece of information was stored. You need any interference with a human right needs to be justified. And they could not justify why this information about the applicants' attendance of trade union assemblies was justified, and it was kept in dangerous databases. There was no correlation. There was no legitimate aim. There was no justification, hence the violation. So this is a very complex issue, and well, the reasoning is the key. State has margin of appreciation. They can argue, they can try to justify, and I think this is a strong suit of German authorities, German courts. And there is one observation I also made from my perspective. When it is the cases against Germany, against the United Kingdom, the courts of which are very well known for the quality of reasoning, Strasbourg court, if it finds a violation, it tries to add more, tries to surpass the quality of reasoning, and that's why those are landmark cases. This is a perspective which I can share with you because, well, our cases, we contributed in a way to development of the Strasbourg case law, but in a very different way. I won't go into that, but, well, we can have another meeting in that regard. So
I was wondering, it's very interesting, and it's of course known that we are trying to compensate the infringement with the right by procedural safeguards. And there are two aspects in this regard, and I have no idea about criminal procedural law, therefore my questions first is, don't we overburden domestic authorities with regard to all these procedural safeguards. It's rather a political question than a legal question.
Right.
And secondly, isn't this jurisprudence, and we have other areas where we have similar developments, leading, at least factually, to a harmonization of, in this case, criminal procedural law throughout the member states of the Council of Europe, which is, of course, not the idea of the European Court of Human Rights, because it's not the European Court of Justice, but it's a human rights court, and it has no legislative competence or anything like that. But we are, to a larger extent, and you showed how detailed that goes into procedural steps of criminal investigation, we are harmonizing procedural law to a large extent.
Thank you. I will start with the last question, if you don't mind. I wouldn't call it harmonization, because this is not for the European Court to order states. Why the court is so popular until now? I won't compare it to other courts, but the International Court of Justice, because it evolves, and also it obligates the state to do something which is reasonably can be accomplished. And it also looks at the consensus, European consensus. So there are areas, including criminal policy, which in which regard court is more cautious. But when it has European consensus backing it up, then it is more stringent with its requests to the minority states. And European consensus can be formed with the majority, simple majority, 46 Council of Europe member states, while 24 is already majority. 24 is a majority, and the minority states can be ordered, when European Court has this European consensus as its backup, change your legislation and practice. And these are the minimum standards. Sometimes the countries itself, they surpass the quality of protection of human rights within their domestic jurisdiction. This is also true. So I wouldn't call it harmonization, but there is also one very important concept, which is universality, universal nature of human rights. Countries, they can't have their particular rights, human rights. They are universal. They need to be interpreted universally. This plus margin of appreciation, it is up to the states to justify the way they want to uphold and secure human rights based on their interests. And criminal procedure, it comes with the, that's why we had this investigation interests. There can be some very particular investigative interests specific to some jurisdiction, and the country may quote it, but what is it about? Justification, the level of substantiating the reference. So it is a complex issue, and thank you for this question, because this is what makes all the systems so beautiful. It's not so clear-cut, and it depends on reasoning. Depending on reasoning and how the states would be using the case law itself, and also justify deviation from it. Strasbourg Court also agrees with that. And the first question, I forgot to write it down. It was about,
just whether we are overburdening the domestic...
Overburdened. I have a theory about that, which I could not go through because of the time limits. All the record of Germany, let's take. So we have overburden, that the state can have these arguments, right? We cannot effectively investigate. First, we cannot effectively prevent danger, and we have to protect those within our jurisdiction. But here we have a very specific test, Osman test by Strasbourg court. Strasbourg court says that the state who could not avert some danger coming from a private individual, it must be foreseeable for the state. They must know or should have known about this danger taking place at this particular case. And it was very well explained in Kurt versus Austria case. Strasbourg court said, see, I will just go into that case very briefly. Man who murdered his own son. The domestic violence was had been directed towards his partner. The Austrian authorities, they assessed the threats, but they did not foresee that the danger would be directed towards the son whom he killed, and not at home where domestic violence had been taking place, but at his school. And Strasbourg court did not rule on the violation of the right to life by the state, because they counterbalanced that with his right to freedom of movement. They did not see the danger. So what I'm trying to say, there is always an assessment. They assessed the danger and they concluded if there was no assessment, that would be the problem. Not that somebody died, a child died, got killed, horrible, but the state cannot be requested to surveil, to restrict everyone's rights just to avert some threats. So this is how it is assessed by Strasbourg court. There needs to be standards that met. In this case, we have Osman test. And again, now effective investigation, which is also again a counterbalancing argument for restricting procedural rights. But effective investigation, it is not about the result, it is about means. Authorities should be doing everything possible within their means to identify someone who is culpable. But if it is not objectively possible, then there is no violation of Article 3. And again, there is a case. Now we go to Article 5, which is right to liberty. There is a case, person M versus Germany, nightclub explosion, investigation and detention lasted for several years of the suspect, and Strasbourg court did not find the violation. Why? Because German authorities, they substantiated the length of the detention. So all this is within the standards. And authorities cannot claim that they need more leeway, more to restrict procedural safeguards. They can't do that because there are standards, what is expected from the state. International law takes into consideration the problem of foreseeing a human behavior, operational restrictions police force might have. Everything is taken into account. And there are very reasonable expectations from the state. That's why I think European courts so popular. There are hundreds of thousands of applications still flooding the court because it maintains relevance. It does not expect something unattainable from the states, and states just have to respect those standards.
Thank you very much. I think we have to stop because we have further lectures at 4. Thank you very much. It was fascinating, the topic on whether we are not overburdening the domestic authorities, but the court, the European Court of Human Rights, is of course another topic, and yes, that will be very interesting to hear about your opinion as well another time. And certainly we will continue this discussion. Thank you very much for everybody.
Thank you very much. Thank you very much indeed.